So good morning, everyone. Apologies for the late start, but super happy to be here and see you now. My name is Alex Peel. I'm the Acting Manager of Community and Publishing Services at Legal Aid BC. I'm stepping in for Belgian Durgill today, who is on a well-deserved vacation after all of the planning she did for the Provincial Advocates Conference. I believe this is our last session of the conference, and so we will go out in style. I'm joining you today from my home on the traditional and unceded territory of the Coast Salish peoples, specifically the Kwantlen, Semiahmoo, Tsawwassen, Katzie, Kwikwetlam, Kaikate, and numerous Stolo Nations First Nations. And I know that many of you are joining us from across different lands and different territories. I encourage you to pop in the chat if you would like to acknowledge the territory that you are on or any other way that works for you. And just realizing that we are on these lands and so grateful to be here. We are recording the session today, so heads up. It's going to be fairly conversational, so we'd like to encourage people to jump in throughout. There's a couple ways you can do this. You can put your question, comment into the chat. We're in a Zoom meeting today, so I think your two options are the chat and the hand raise function, and then unmuting yourself and speaking. Both of those are options available to you. I will be monitoring the chat. I will also be watching for people with raised hands, and I will be interrupting our speakers to ask your questions as they come up. So please mute yourselves when you are not speaking. If you forget to do that, I think we can do that on our end. Sometimes I mute people just for the fun of it when they're speaking, but I won't do that today. And I will mute you though if it's background noise, and then just remember to unmute yourselves when you want to speak. I always like to tell people that I come up with my best ideas that I share when I'm on mute. No one ever knows about them. So remember to unmute yourself so we can hear you. And with that, I am going to turn it over to our speakers to introduce themselves and introduce the session.
Good morning, everyone. My name is Dhanu.
And I'm Uphar Dhaliwal.
I want to start by saying, well, first of all, I picked a really bad purple shirt to be with a burgundy book background. Very bad contrast, so I apologize for that. But what I can say is that it's very cool, and we present oftentimes, but I don't acknowledge this, that's very cool to be presenting with my wife and my law partner.
So just a little bit about us. Not only have we been married for a couple of decades, we haven't killed each other, though we probably at some points have felt like it. We actually work very, very well together because our areas of practice are also intersecting, and that's what our presentation is on today. Rob practices criminal defense law, I do family and immigration, and I do some CFCSA work as well. So these areas, inevitably for families, the intersects are happening on a regular basis, and unfortunately, lots of people don't know how to handle that. So we're very, very fortunate that we practice together, we practice in these areas, and we're able to run things by each other. So our goal here is to be able to have everyone think about some things that, because I think everyone here is an advocate for individuals and take people out to lawyers and kind of help them with some things that they may not even be thinking about. And sometimes, unfortunately, even their lawyers don't think about. For example, the immigration consequences, for example, the family and the criminal consequences. So we're hoping that we can add a little bit of extra thought to everyone and have maybe a little checklist for you that you can use when you ask people about their background, so you can help them better.
And look, we always appreciate your time. We appreciate your attention. We're very happy to be here. It's always nice to know who you are dealing with in terms of speakers. So I'll give you some background about myself to start things off. So I started off my career in the law as a federal crown prosecutor for the Department of Justice. So that meant that I was dealing primarily with gangs, with guns, and those types of issues. So not really domestic violence. So the experience I did have with domestic violence was by virtue of the fact that I was also on the Yukon flying squad. And because the Yukon, or now just called Yukon, there's no that anymore, is a territory. It is run by, of course, Ottawa, the federal government. So when we would go up there, we would take our federal crown hat off in terms of our guns and drugs hat, and we would put on our provincial court hat. And so I would become a provincial crown, I would take on the role of what a provincial crown does typically in the provinces there. And that's where I would experience from the crown prosecutor side of things, domestic violence issues, sexual violence issues, and issues of that nature. Eventually, I left the Crown and I went on to start a criminal defense practice. And then Uphar would later join me, and we would create the Dhaliwal law group. So now I deal with domestic violence cases for sure on a weekly basis, almost on a daily basis. And not only do I represent accused persons, but I also represent individuals who are complainants or victims of violence as well. So I see it from both sides. I think that's really important in terms of giving you a perspective from both sides of the coin, not only as Crown, but also as a defense lawyer.
And I've been practicing, I started my career in the United States, and then I met this handsome young man and came into the
Not
country.
very young anymore, or handsome.
You still are. And I came back, and I've been practicing family and Canadian and US immigration. I've actually helped individuals who are dual citizens and maybe their partner isn't come up with a good plan to leave the country and not have to worry about what they're leaving back here because the domestic violence was so bad. What I want to say to everybody here, we all do really hard, really heavy work. So we got to have a sense of humor. So throughout here, throughout our presentation, we may misbehave a little bit, but we have to in order to stay sane.
It's completely true. You know, sometimes people get upset when they see police officers laughing at a crime scene, but that truly is, it's a protective function. And if we internalize everything on a very deep level, you will literally take on so much stress and so much pain from the individuals you're dealing with that one individual simply cannot handle it. So first of all, kudos to everyone who's doing this type of work. It's not easy work. Both on the family side of things, on the criminal side of things, as well on the advocacy side of things. The work that you do, it's amazing work. It's amazingly fulfilling. And you know those moments when you have that fulfilling feeling, when you felt that you've helped somebody, but it is also very stressful. And mental health is an issue that we're all dealing with, especially now through the pandemic and quarantine time. So give yourself a break, let yourself de-stress and be kind to yourself as well. I think that's really important too. So in terms of starting off, I love history, I love sociology. I like to take a macro view of things before we get into the nitty gritty. So we'll talk about all the well, not all the intersections, but certainly some of the intersections between family law and criminal law. But we have to recognize that domestic violence is an issue that stretches throughout history. It stretches throughout every single culture that we have that makes up this amazing planet of ours. It's not gender specific, and certainly women are the majority of the victims of domestic violence, but men are too. It also, in terms of gender identity, it's statistically shown that individuals who are LGBTQ plus suffer more domestic violence than non-LGBTQ plus individuals. There is a huge, what we call a dark figure as well in terms of domestic violence, and that what we're dealing with out there in the trenches is the tip of the iceberg. And by dark figure, what we mean is that the vast majority of domestic violence is actually not reported. So we're dealing with just the tip of the iceberg. There is probably 90%, if not more, of domestic violence actually does not ever get to the stage where anyone else knows about it, other than the people who are involved in that scenario. It also does not discriminate between socioeconomic status. So it's not a poor thing, it's not a rich thing, it's an everyone thing. And we saw that most recently in the Johnny Depp case. I'm sure a lot of people were following that as well. But it impacts everyone from every different walk of life. And that's really important to recognize.
And we have to remember that domestic violence not only comes in the physical form and the emotional form, our courts recognize financial abuse. There's case law about that. So that's something that's really important because that's control and coercive control. So sometimes we get these cases where we'll have people, and I get them regularly, and I'm going to say it's mostly women, where they will say, I don't have access to the funds, I don't have access to any money, I don't know anything about our financial circumstance in our home, and I'm not going to ask because as we're working out a plan for them to leave, that will be the first thing that will tip off a person, and they're in a heightened place of danger. And I think we all know this, and we can all recognize that when relationships end, that period right after that initial separation or at that time of separation, for that first year, that's a very critical time. So getting all the right things in place will help with the trajectory of how that family separates. So that's something that's really, really important. And sometimes we have to remind people that let's not forget that stat, that we know this person is in the most level of danger now that they're going to actually leave this relationship.
So what is the biggest intersect between family law and criminal law and immigration law? And I'll begin with the family. I'll begin with actually with our own example in terms of how I realized what the biggest intersect was. When I left the Crown and started my own practice in Vancouver and downtown East Side, you're not just a lawyer anymore, you're also running a business. So I started noticing, what are the needs of my clients? And what would happen would be that I would get a domestic violence file, and inevitably there would also be family issues that would come along with that. And at that time, Uphar was a solicitor. She refused to litigate. She did not want to leave behind her desk, but she had definitely the personality to do so. And when she left her work and we decided to start off a business and a law firm together, I said, well, look, there is a huge need. And especially in the South Asian community at that time, and I think there still is in immigrant communities, for family lawyers. And so I dragged her kicking and screaming from her solicitor practice into a litigation practice. And I said, here's all these referrals I've been sending elsewhere. You need to do them. And if we do them together, we can be a great team and represent our clients' interests, both on the family side of things and the criminal side of things, in a much more integrated way and a much more effective way for our clients. And we've been doing that ever since. So the biggest intersect really is it's the violence, right? So when you have a charge of assault or assault causing bodily harm, and oftentimes there's an uttering threats charge that goes along with that, that leads to family law issues, in 8 times out of 10. And that's really where you see the beginning of this and the biggest intersect between these two practices. So I'll start with asking Uphar a question. How do files start on your end, Uphar, when there's an intersect with the criminal law? So say there's not a criminal charge necessarily, but a client has come to you and there's an allegation of a history of domestic violence.
Well, let's first start with the person who is the accused. So if somebody has been charged or they're going to be charged and they have some concerns, we're going to talk about usually the people that come, they've already been charged and they have some bail conditions. So the very first thing that we have to look at is, okay, now criminal lawyers, I'll say they don't ask what happened. Family lawyers, we ask what happened. It's just a different way of practicing law, and the standards are different. So for family, I'm going to ask somebody, okay, there's incident, what exactly happened? And you're not able to, I have to look at the bail conditions, because many times there's the bail conditions say either they can see the children or they can't see the children. And what I mean by that is the bail conditions will specifically either eliminate the children, they're not mentioned in the conditions. It'll be just against the partner the victim, or it'll include everybody. And the way to look at that is the next question I would ask is if the children were included. Okay, so while this incident occurred, we're going to call it an incident, who else was there? Were the children in the home? Were the children nearby? I have to ask those kinds of questions in order to know what next steps we have to take. So if children have witnessed abuse, we have to take a really different approach to this, because I look at it like this. If somebody who's come in and they're an abuser, I don't want to help them continue abusing. I want to help them get the help so they can actually make their family better. and be able to see their children in and be in a better light. I always remind people that apologies go really far. So now when a person comes in, typically with a criminal charge, the ministry is also immediately involved. So when the ministry is involved, and the ministry being involved, things are quite slow. So that's, I'm not going to go on a rant there because I'm going to behave. The ministry will take their time to go and do an investigation, and they're going to do an investigation to see if that individual is safe. So if that individual is safe, they're going to come back and have a report, and I usually ask for a letter, and at that point I'm going to either connect with the opposing counsel or going to try to get into court to say, hey, look, let's try to resolve this as amicably as possible, because children need both their parents, but children do not need an unsafe environment, and generally children need both their parents. But if somebody is, if there's a one-off incident, we know that it's not really a one-off incident. What happened to have the pot boil and the steam came out, something broke, and at that point the police ultimately did get involved. So with people who are the accused, we try to work in a way that we can help to get supports in place, and we'll try to help to get them getting some initial parenting time, because if you don't do that right away, they're going to, that's detrimental to the family, it's detrimental to their case. Now let's go on to the flip side, where I've got a victim who's come in and has said XYZ things happened to me. I want to know, well, what exactly is this? Is there a history of this? Have the children in the past been there, seen things, what's happening? There's been times where the children are not included in the bail conditions, and I've called the Crown to ask why not, and on their next court date, we've had them included. There are other times where I will have a person who'll say, actually, this is between me and him, and I do not want, and I'm saying me and him purposefully, I do not want the children to not be able to see their father. So then we have to do a workaround with that, and then that's usually when we'll get our criminal team to say, hey, we need to get the bail conditions varied. On this side, can you reach out to criminal counsel, and if they don't, we try to do some of that ourselves. So the goal at that point is, let's have these families, let's keep the temperature down, and let's try to come up with something holistic. And what we have to remember, most people that come to us, they don't necessarily want to separate, especially when it's the criminal charges, right? I'm not talking about just the people who are coming for family law advice. Some of them are coming to actually ask, hey, how do we, I don't want this happening anymore. I do not want the abuse. This has to end, but we need something. Somebody has to stop this. So then we'll see what community resources we have in their specific language, in the particular area that they're in, and of course in their affordability. We have lots of low bono and pro bono help out there, and we try to connect these individuals in that regard initially. So that's for the families that don't necessarily want to separate.
Yeah, so where a file starts is really fascinating for a criminal lawyer, because we really want to know, why were these charges laid in the first place? What's the motive? And it's really interesting because when we have clients, oftentimes the situation is that the client is denying the allegation. And they're saying, well, look, this never happened. This is being made up. And what happened is, what oftentimes the client will tell us is that, the relationship was not going well. There's all these issues that have been ongoing for some time. It seemed like we were about to separate, and she wanted me out of the house. And now she's laid these criminal charges on me that are untrue. And she's using them as a sword, and using the law as a sword rather than as a shield, as it should be used, and as it's meant to be used. So it's always interesting for me trying to figure out what's going on the family side of things. So when a client is sitting down with Uphar, the defense is theorizing that, well, the the lawyer is trying to dig up information, is trying to get leverage on the family law side of things by laying these criminal charges. Now, of course, Uphar would never do that. But this is the theory of the defense, is that these charges are being used to gain advantage either with exclusive possession of the home or with custody of the children. And so that's always really important for the defense lawyer to explore in terms of how did these charges start out. So Uphar, just in terms of a question, if you have a client and there's no criminal charges laid yet, the client has come to you and there's no, the police are not involved at this stage, to what extent do you go to explore the history of violence, and how does that assist in the family side of things?
Well, I really want to know what's happening between the two of them, because a lot of people that actually end up in court are what, as one of the judges is called, the Bickersons. And and it may not be a completely equal playing field, but there's lots of argument going back and forth. So I actually want to really try to understand who's in charge of what. For example, okay, who's in charge of the children issues? Who's the one that does pickups and drop-offs? Who stays at home? Who's the breadwinner? Okay, who makes dinner every day? Because you learn so many things from the little questions that you ask about the family's dynamic. And you have to also ask, who else is living in your family? Because are there, and I'm going to call them the shit disturbers, excuse my language, because are there other family members that are living in there that help to promote and support one of the couple, one of the members, and in abusing the other person? So I want to kind of know these kinds of questions. So sometimes I'll have someone and they'll tell me, yeah, my parents live with me. And then I want to know, how's their relationship with your spouse? How do they get along? And I hear things like, oh, my spouse doesn't like to make them tea and doesn't ask them if they're, how they're doing, and they don't really have a good communication. But of course, we have children, so I'm learning a lot about that dynamic, right? And on the other side, I might get this woman in, and she might come and say, well, actually, my in-laws live with me, and they expect me to do everything, and they can't even help me with the simple making a cup of tea. I'm expected to make them a cup of tea. That same scenario from two different people is told a different way. And lawyers, our job is to advocate, but to really serve your client well. I want to really understand as best as I possibly can the actual dynamics. And of course, I recognize that the dynamic is going to be from the view of the person that I'm talking with, not from the opposing party. So then I want to ask, well, what's the other party going to say? What's your spouse going to say with this same question? And then usually there's a little bit of a chuckle or a aha moment, and then a different answer comes out. So that tells me a lot. That tells me a lot.
And so from the criminal side of things, this is how it starts. It starts with an arrest. I'll take you through the process of when we get to the family lawyer. So we have an individual, and typically this is an individual without a criminal record. So most clients that come to me with the domestic violence allegation do not have a record. They don't have a history. So you have an individual who's trying to navigate a completely alien system, who has not had much police interaction in the past, and they are arrested typically in their own home, oftentimes in front of their children. One of the things we often hear is that there was an argument. I went to bed, and then suddenly the police are at my door, and I was accused of assaulting my spouse when I never did. So they're given a few moments by the police to put their clothes on, they're handcuffed, they're read their charter rights, and then they are either released on conditions, on some type of bail conditions, and the typical conditions you're always going to have are a no contact with the spouse, a no go back to the residence, keep the peace and be of good behavior, which means generally be good, and to report to a bail supervisor. Sometimes there's a no contact with the kids thrown in as well, which can make things even more traumatizing. The other scenario is if they're not taken into, or they're not released at the scene on some type of bail documents, then they're taken to court. So now they're sitting in cells at the police station. The first time that they've ever been arrested, surrounded in a very difficult environment by some very difficult individuals. They're brought before the judge. This allegation, in terms of the basic allegation of violence, is made in open court, and the judge will set bail conditions very similar to what I've already outlined in terms of no contact, no go conditions. then they are out of house, they're out of home. And this is really, it's a very difficult situation. Just imagine if tomorrow you woke up and suddenly you weren't allowed to return to your residence. You weren't allowed to see your family. You didn't have the roof under your over your head that you currently enjoy. You didn't have access to all your personal belongings, your documents. Maybe your your credit cards are at home. You have no money. You have no ability to access your accounts. It is an extremely difficult and traumatic situation to suddenly be out of house at home and not knowing which way to turn to. And that's when the client will often retain counsel. And what I want to know in terms of the client coming to me is, it's really important, where do you see, what is the future? Is this relationship over? Do you want to continue in this relationship? Do you have any idea of what your spouse wants? Does she want to continue in the relationship? And you'll get various answers. Some clients will say, well, no, it's over. I want to initiate divorce proceedings. Sometimes there's already divorce proceedings or some family court matters underway. And other situations, and I think probably the majority of situations, the spouses actually want to stay together. So in terms of what the client wants, whether they want to reconcile, whether they want to separate, that plays a huge role in the defense lawyers, or should play a huge role in the defense lawyer's strategy in terms of how to conduct that file. And one of the first things I'm going to do is to see if the spouse has a family lawyer and where the spouse's state of mind is at in terms of how to proceed. Because if we're trying to reconcile, we're going to go on a very healing path where we're not trying to create more wounds and division in the family. We don't want to go to trial. We want to reach out to Crown. We want to reach out to the family lawyer, if there is one, to see how we can get these parties back together on a healing journey. And if the relationship is over, well, then things might be different in that we are prepared to go to trial, prepared to cross-examine the complainant and see where the chips fall. And sometimes the clients just don't know. They simply don't know where the headspace of their spouse is at. They may not even know where their own headspace is at in terms of what they want to do. And then you have to slowly gather information to figure out which path you're going to take and where the parties are all at.
And one of the things that I want to add is what I see, what my particular experience has been, is majority of the clients that I get are the people that have already decided they're going to be out of this relationship, and they're usually the partner that has been the victim. They've had enough. They're the ones that want to start this typically. Where I see them coming in from, for example, a referral from the criminal side, is they're partway through the process, where in the criminal proceedings, there might be a couple of dates that have been set, trials further down. They've already done this. They've already figured out whether the parties are separating or not, and then usually the husband or the man, the male spouse, comes to us and then will ask us questions along the lines of, okay, I haven't seen my children in months. What do I do now? I was hoping we would get back together, but that doesn't seem like that's going to happen. So now one of the things that's happened there is there's a huge segue. Months is a long time for children not seeing their parent. So we have to figure out, what have you done to heal? What have you done to better your behavior? Have you taken some anger management? Have you got some courses? Have you done some counseling? Do these children even want to see you? And usually I get some responses of, yes, we've done X, Y, Z. And if that's actually quite helpful, because then I want to ask, is the ministry involved? Have you talked to a social worker? And sometimes, because of they're working with the criminal defense lawyers, they're afraid to actually talk to the social workers, thinking that whatever they say and do is going to be used against them, but they're totally, completely separate matters. So if people want to fast track their family, getting their family together and seeing their children, I will usually advise them, let's get on the phone with a social worker. I'm going to be a part of that because I'd like to hold them accountable as well and say, what exactly is it you're looking for? I've got Mr. So-and-so here, and how can we help? And what's missing here? What's taking so long? And then I learned, oh, he didn't answer any questions, didn't take any responsibility, and it says that nothing happened. I'm like, okay, well, there's two things. Well, maybe Nothing in his view, nothing happened. Or maybe something happened and it was different than what you've learned because you've only had the report of one individual. So why don't you talk to this individual? And I help the client say, now you're going to talk to them. And if they recommend any type of counseling or if they recommend any kind of resources, you're going to take those up, because even as the criminal proceedings are continuing, I don't want your family matters to slow down so much that the gap between you seeing your children and the actions that you should have taken to actually speed that stuff along are going to set you behind. So, for example, if they're talking about counseling, alcohol, we all know is a huge problem. Drugs and alcohol is a cross-community problem, a cross-cultures problem, some cultures more than others. So we really want to deal with that, because sometimes that's the biggest elephant in the room. And then I have a frank conversation with people and say, look, we need to get the help and the resources in place. Are you going to choose these things, or are you going to choose your family? How are we going to help you make that decision? Because obviously this is a crutch and we need to help you get away from that. Now, on the flip side, let's say I've got the victim partner in. I want to know why they're not feeling safe. I want to know what is it going to take to make them feel safe. I want to understand what's happening with the children. Now, if the children are at an age where their views can be considered, I definitely want to do that. And that can be done multiple ways. One is a Section 211 report, and these come in different fashions. A Section 211 report, the most expensive and what they'll call the Cadillac that nobody can afford except for maybe 2% of people, are the where there's a psychologist that does a that interviews both the parents, any other family members that are living with them, and also the children, and then gives a report to the court for the purposes of how parenting should be decided. The other is the Section 211 reports that are done through the justice counselors. These are free. The problem with these are they take a year. The wait list is just atrocious. So we have to come up with something in between. You can use, I will send, depending on the age of the child, so usually 9, 10 and up, depending on each child is different. Some are very articulate. The Youth and Child Society, they also do reviews, and they can actually come in as counsel to have a voice for the children, and that's free. Also, Hear the Child Society, there's a roster, and they can write reports, get the views of the child in, and these are non-evaluative. So there's two different kinds. Evaluative, which are different than the non-evaluative. Non-evaluative, they're asking questions to the children to get a basic idea, just to get their voice in. And that usually helps, just like I ask the questions, well, what would your partner say? What does, in the opposite, would help a court understand. And sometimes it helps parents understand, yeah, my child's telling the truth. I understand why they feel this way. These are the things we need to do to better this. But that will help both the parties, and it will help the child or children have their voice into the court. And even though court sometimes is a very archaic way to resolve a family's matters, that's the only way people are going to be able to get some help, because they're poles apart. And the reports that are done by these various entities are an excellent way to be able to give a little bit of shine, a little bit of the children's view. So, for example, we just want dad to stop drinking alcohol. If he would just stop drinking alcohol, all of the problems would go away. And, mom has filed an affidavit that says he's an alcoholic, and then his behavior escalates when he has alcohol, and he's a very different person when he doesn't have alcohol. But dad on the other side is saying, no, I don't have an alcohol problem. They're exaggerating things. Well, why is this child saying that we just wish dad would stop drinking? They're not saying we don't want to see dad. They're saying alcohol is a problem. We just wish he wouldn't do this. That actually speaks volumes in court, right? And usually before you even have to go to court, you want to take those and write something from us. We would say, look, this is a problem. We need to have this dealt with. Let's come up with a program. Let's come up with a plan to resolve this. And I have to remind people that just because there's drugs and alcohol are a concern doesn't mean the person with those issues does not get to see their child. They can see their child through some, just like this on Zoom or Facebook, or not, what are they called? Video calling of different types. And they can do professional supervised parenting time. They can do with another family member, sometimes out in the community. So there's different ways to create options for people to be able to see the child that's safe for the child, and continues to support having a parent-child relationship, because at the end of the day, a parent-child relationship is extremely important.
To get on that path, one of the other big intersects we see in family and criminal law is dealing with.
Hi, sorry to interrupt. We have a hand up, maybe a question for what Uphar was just asking. Sarah, go ahead.
Hi. What I often see is the partner who's left in the family home, and maybe the partner who's been charged is no longer paying the mortgage or the car loans. And of course, going through court, these matters would take quite a while to get sorted out. And I've seen lawyers who've said, you know, you can contact a probation officer or Crown Counsel or the Defense Counsel and potentially get these things worked out. And then there seems to be lawyers who aren't necessarily open to that communication. So I was just wondering what you thought was the best way to deal with this issue.
Well, I mean, I want to understand the family's financial picture. What's their actual financial picture? Were they living paycheck to paycheck, or is this partner who's now no longer paying the mortgage have other assets as well? And this is just another way to do some financial, some abuse, right? This is financial abuse. But remember, child support is a right of the child. Spousal support is not. It's on a needs basis. Those things take priority over getting a mortgage paid. Now, I also remind people that banks are not going to come and foreclose on your property instantaneously. But where there's a catcher is the property's in the person who's in the home's name and not in the other person. So they're worried about their credit. They're worried about all sorts of different things. So we will try to write as soon as possible to the other party and say, look, this is a real concern. We can get into court. We can get into court on short leave. You don't have to always follow the process. You can go to court on short leave and ask. But before a judge makes an order for a mortgage to be paid, a judge is going to make an order for child support to be paid and spousal support. So lots of times I've got some wise people that are starting to come, and what they'll say is, I want to end this relationship. How do I go about doing this? So I'm like, well, the first thing you need to do is I need to know the financials. So before you even leave, please take a photocopy or take a picture of the tax returns, the bank statements, and those types of things, so that I have this and I can take that into court fast. And then I can say, look, we need an order for support, or we need, we can also do, we can freeze accounts. And if accounts need to be frozen, that's something that lawyers shouldn't hesitate to do, because sometimes you get the account frozen, all of a sudden there's a wake-up call when the other party has no access to money, that, okay, let's get back into court and resolve these issues. And the rule is, when asked, a court must do a Section 91 order. And that's the financial restraining order. And then you take those financial restraining orders and you write a letter to the bank and you say, I've got this restraining order, freeze all these bank accounts. It's amazing how fast you can get action on just that. Usually within a week, you have some agreement to some kind of resolution. So that's something that I think is an excellent tool that we have in our tool belt.
Yeah, that's a great question, Sarah. So from the criminal side of things, one of the big issues that criminal lawyers deal with is just how restrictive those conditions are. So just imagine you're now out of your house, you have a no contact order, you have a no go. So you don't even know, you can't have any communication with your spouse. So if you were paying the, one person was responsible for the bills, one person was responsible for the mortgage. In terms of finances, you simply can't even talk to your spouse to figure out, how to deal with those finances. Oftentimes we have individuals from the criminal side of things and the accused perspective whose business is run out of the home, and who can no longer engage in their livelihood. So they want to get back home for financial reasons. Oftentimes you have situations where you have children in the house and now there's no contact with the kids. So one of the first things we have to consider, what happens from the criminal defense lawyer side of things, is that The family lawyer may give me a call and say, well, look, your client's not paying the mortgage. Or Crown may pick up the phone, and this is more unusual, but the Crown in the past has picked up the phone and says, well, look, the client's saying that there's no money in the account. So one of the first things we want to deal with is to get those bail conditions changed so there can at least be contact. Typically, it's in the interest of both the accused and the complainant to pay the mortgage because they both have, a lot of money riding on the house, and that is going to be fought over on the family side of things anyways. So I don't see too many situations where an accused person will outright refuse to pay the mortgage. There are situations where it's a really messy set of circumstances, and there's some level of vindictiveness, and the client just simply wants to have some level of revenge against the spouse. And in those situations, I encourage the client to really take keep a cooler head and take a long-term approach to these things, because those factors do impact the family side of things. So I'll say, well, look, yeah, sure, you may not pay the mortgage, or you may not be putting money in the account for the kids, but how's the judge on the family law side of things going to look at that? So even if you don't want it to do it emotionally, just do it for your own best interests, right? It's really important to, even if the client is very hot towards the complainant, to get them to use their logic and common sense so they at least see what their own interest is, that type of situation.
Yeah, and sometimes you've got a hot-headed individual and they're like, they want revenge because now I've been charged. They don't see what's wrong with the whole picture. So then I have to help them understand that. And some of the things that I'll ask them, so if you had the children, would you feed them? Yes. If you had the children, would you make sure that they had clothes to wear? Yes. If you have the children, would you make sure they had a roof over their head? Yes. I said, then why are you stopping? Why are you preventing your children from having that now? It's a right. You're terrible, and your children are never going to forget this moment when their mother was struggling and they were sitting there watching and they were helpless. All of a sudden a different light goes on, and you can help de-escalate the crazy and get something happening. And sometimes it takes a little while to get that, right? And I think each lawyer has their own approach. I've been doing this for long enough where anything that drags the process out, doesn't matter what side of the of the litigation you're on, you're ruining this for both people, and you're causing more damage, financial, emotional. Litigation, separation in and of itself, this is traumatic as well, and it shouldn't have to be traumatic. So it really depends on the approach that you take. If you can help to take the trauma out, if you can help, even people who are the accused have gone through trauma. And I think that's something we also have to always recognize. Let's get everybody the help that they need, and help. They don't have to be together, but let's help them become half decent human beings, because these children are going to play with our children in the future, and we don't want. We want them to learn how to play in the sandbox.
And we have to remember, the criminal law is a cudgel, not a scalpel, right? So when you put roadblocks in the way, and you have to have bail conditions because there's safety concerns, and those are required, but they have to be balanced with looking at what the nature of the relationship is. Are these individuals trying to get back together? And if you cut off all communication, you're creating a huge hurdle for that family unit to even begin to engage in that process, and to try to figure out what they want to do. So bail conditions last for the entirety of the criminal case. So until the criminal case is over, if there's no contact condition and it's not varied, it's going to last right up until the very end of that case. And can you imagine if you have no communication for a criminal case that's lasting a year, how is that going to assist the parties, whether they're separating or whether they're going to be together? Once again, balancing those safety concerns. So we take a really a step-by-step approach. So what we're going to do from the criminal side of things for bail conditions is I'm going to ask the Crown to, is the complainant feeling safe enough to have at least phone contact, or perhaps it's email contact? Let's get the process started in terms of opening up the lines of communication so that we at least know where these parties are going. Bearing in mind, of course, any safety concerns and any fears that the complainant may have. And then the Crown is going to interview the complainant. They're going to suss out those concerns. And then we begin a dialogue with the Crown and we see where that takes us. And oftentimes when you have individuals who want to reconcile, want to get back together, is evolving bail conditions. So you'll start off with telephone contact, then you'll be have conditions where you're allowed to meet in a public place. And then you'll have conditions where the individual is perhaps even allowed to come back home. But it's an evolving process, and one in which those safety concerns are always kept foremost in mind from the Crown side. So just for a question for you, like, what are the main issues that come up with bail conditions on the family side of things that you see?
Well, the no contact issues, right? So it depends, and you know that it can be used as a shield. I see that happening all the time. Well, if I'm representing someone who is a victim, and she says to me, and I use these pronouns interchangeably, right? I mean, you never know who you're going to have as the accused person. So typically, it's a woman, and using the her and she pronouns. So that's what I'm going to use. So she comes to you and she says, "Hey, my children are afraid of their dad right now. We want to make sure that they get some help. We don't want them seeing each other." So the bail condition is one level of protection, but in some scenarios where it's there's heightened worries and fears, I'm going to go to court and get a protection order, an exclusive occupancy order, and a couple and the freezing orders, the restraining orders, the financial restraining orders. And what that will do is also help to bring some of the temperature down. But these are not forever and ever. You can't use that. The goal shouldn't be that this is now going to be in place from now until the trial is heard. We have to, if an individual on the other end is making some kind of progress, then we want to be able to say, okay, have some conditions. When this type of progress is made, some counseling has happened, then let's do some third-party professional visits. Some third-party professional visits after we have 3 or 4 of these and we get good reports, let's get it out in the public. Now let's see how these things are going, how the children are doing. And you want to have a scale of how you do this, of incremental growth. However, there are those files where the trauma is so severe, the behavior was so atrocious that's not going to happen. And we're not closed-minded to those. And that's where you have to go full stop. We want a protection order. We want all of these things. And we're not interested in changing them until we see some positive evidence. And then, even then, we want to go to court and we want a judge to have to make a decision, because the person who this has happened against and the children are not in a place where they want to see or hear from their parent. I'll give an example. We've had a few clients where one of the parents has died at the hands of the other parent. So now we're representing the children or close to being adult children, and parents that are the parent that's incarcerated is continuously calling the children to talk to them, to try to reach out to them. The mess that individual caused, these children are not ready to be able to talk to this individual, right? So we have to help have heightened. We as lawyers are their buffer. We are their wall when they need us to be their wall. We are their tunnel when they need to, be able to get through and do things. So we fully recognize that, and we're going to help do the right thing and make the right pathways for these people to move their matter along. So all different families come with every story is different. There can be lots of similarities, but how we focus the solution is going to be on the needs, the wants, the desires, and something practical. Like having a practical solution is always the best. Sometimes people's mental health gets in the way of what might be practical to me. And then we're going to work on that as well.
Just segue with that, one of the other areas where criminal and family law really intersect is dealing with MCFD or the ministry. And criminal lawyers are always loath to allow their clients to say anything to anyone. And one of the first pieces of advice we give our clients is, do not talk to the police, do not talk to anybody. That can be used against you, it can really hurt you in your case. And so criminal lawyers are stuck in an uncomfortable place when it comes to the ministry, because if we give them that advice with regard to the ministry, that can lead to less access, perhaps even no access in terms of the children. So criminal lawyers have to step out of their comfort zone when it comes to balancing the client who is desperate to see his children with the criminal case and trying to make sure that the client's rights are protected. So what we advise is to be open and forthright and really to play ball with, at least this is what I advise, to play ball with the ministry without getting into the facts of the case itself. You really want to show, and this is what we tell our client, is that you are prepared to do whatever it takes, jump through whatever hoops and jump over whatever hurdles the ministry says you should to assuage any safety concerns that they may have, which will allow you access to the children, but without getting into the details of the case and throw me under the bus, sorry, in terms of your counsel and say, well, look, my lawyer advised me to do this. I'd love to talk to you, but my lawyer told me I can't talk about the facts of the case. So, Uphar, what do you tell your clients when the ministry is involved and there's a criminal case in the background?
It depends. If I'm representing the accused, I'm going to tell them that I actually like to get on a call right away with a social worker, or I'll write to the council. I'll write to director's council. And what I want to do is say, hey, look, we need to build some bridges here. There was an incident. And I understand that the social worker wants to be able to talk with my client. My client's happy to be able to do that. Because there's criminal charges, I think it's best that counsel be present, and we understand that something happened, and he's not going to admit or deny. We'll say that something did happen and he's willing to get help. And what are the resources you're offering? Come take a look at the house and see what his living arrangements are, so you can assess for safety. If drugs and alcohol are an issue, then we want to get some resources in place that will help to help with that. So, I mean, I always tell my clients, because sometimes they're hesitant with something like that. I'm like, when you say sorry and you say, I'm ready to get help, what is a person going to say against you? It's hard to blame you when you're saying, yes, I take responsibility. I don't see it the way that you see it. And it didn't happen the way that you say it happened. However, I'm willing to do ABC because my children matter more than me. And I want to start seeing them. And those that agree, those files just move faster and things happen faster, but some won't. And that's okay, because we can't push, but that's something that we do see. And on the other side, if I've got somebody who says the ministry's involved, I'll tell them at times, make a safety plan. Let's get a safety plan in place so that they cannot, you're not going to allow, because the children can get removed from the other parent too, and we don't want the children removed from the safe parent. So that safety plan is entered, and until the other party goes and works with the ministry is going to act as a shield to help, and we'll use that in court for their benefit, because clearly there's a problem, clearly it needs to be resolved, and the ministry has put these conditions on this individual vis-a-vis this safety plan, that if you allow him to have unsupervised visits or you let somebody else, that these are not going to help. However, courts can make orders that will still give parenting time, that will still do all sorts of things, and the ministry has to abide by some of that. And if I know that the ministry is going to take an issue, I try to get the social worker into court to come and speak to what the ministry's concerns are, what action the ministry is going to take if the court makes an order. For example, you can have the weekends with the children, and he hasn't gone through what needs to be gone through with respect to the ministry. And if the ministry file's totally closed, that's something that will it reopen if the other parent starts, if there's an order for parenting time that we have to deal with.
Yeah, we have to understand the ministry is typically involved very early on in the case from the criminal side of things. So a person will be arrested and charged, and the ministry is there to help ensure that the safety of the complainant and if any children is protected. And that's typically even before the accused person has their disclosure. So defense lawyers are operating blind in terms of what the facts of the case are. Certainly we have our client's version of events, but until we have the complete picture, we can't really even give proper advice in terms of what the roadmap is to deal with this file. So we're really careful in terms of what the client discusses with ministry officials in terms of the details of the case, but for anything else in terms of getting access to those children when there's counseling, we certainly encourage that, which takes us to disclosure, because we want that disclosure to get the full context of the case. And as Uphar indicated early on, family lawyers and criminal lawyers are quite different in terms of how they deal with their clients early on in the case. Early on in the case, I don't want to know too much about the facts from my client, because the client simply does not have the disclosure yet. Until the client has a full picture of what occurred, I don't want that client telling me too many details, because what the client thinks the complainant is alleging may be very different than what the complainant in fact alleges. Oftentimes we have clients who say, well, look, I think it's just an argument we had one night, and she's saying I pushed her, and then we get the disclosure and she's alleging years of abuse. So we don't want those inconsistencies on the front end. We want to make sure the client is fully aware of what's being alleged so that they can give a proper response and they're not handcuffing their counsel in terms of how to proceed. In terms of the intersect on disclosure issues, and I think advocates are also interested in disclosure for various reasons, and depending on the circumstances, but family lawyers often ask us for disclosure, and criminal lawyers cannot provide that disclosure. We're on an undertaking when we receive that disclosure that we're not able to provide it to any other counsel for any other type of legal proceedings. So we have to tell that lawyer when they ask us, sorry, we can't do that. You'll have to get a court order. We are, on the other hand, very interested in any affidavit material that has been filed on the family law side of things, because we are going to, if we're doing our job properly, take a look at that material in close detail and then compare it to the disclosure we receive on the criminal side of things. And oftentimes there's a big discrepancy between what has been reported to the police and what information and material has been provided to the family lawyer. And that can be for a number of reasons. First of all, the family lawyer is going to spend typically a lot more time than the police are with that individual. So they're going to draw out much more information. On the other hand, another reason why there may be discrepancies is because the police are going to be a little bit more discerning. So they're operating from a different perspective, and they're going to be questioning some of the allegations that are made possibly. Whereas the family lawyer wants to get more information and more ammunition that they can use to assist their client on the family law side of things. So what the defense is looking for in terms of the affidavit materials, anything that we can use to impeach the credibility of the complainant if it comes to that at the time of trial. Another issue that arises in terms of disclosure is that the client has been charged with an offense, and they've filed affidavit material without even receiving the disclosure yet. So that can create a lot of problems for my client. If they go out and say a lot of things on the family law side of things and they don't have the disclosure, that can come back to haunt them as well. So, Uphar, in terms of disclosure issues, are you interested in disclosure on a criminal file? And why would you be interested in that kind of disclosure?
So it depends. If I'm representing the victim, that person already knows the report that they made, the statement that was given. So I really like to ask them if they could get a copy of that before I make an affidavit, and they can explain exactly what happened, because then I want to make sure that the affidavit that we're listening to, I can have some questions to this person and say, okay, you said you were hit on the shoulder on your right side here. Is it on your right side? Because I warned them, I'm like, when you get cross-examined on this, they're gonna, if you go ahead and say I was hit on my shoulder on the left side, that's gonna diminish your credibility. So I believe them when they come and they tell me that they've been injured, but then and they've been hurt in something. I want to know what the story is and make sure that help them understand what inconsistencies will do and how that will damage their position in their criminal proceeding, because they are an active participant in that. They don't get to choose if a charge is laid or not, but they're going to go and testify, and it's traumatic to have to testify. Anything that they say can be used against them. So I always remind them that, look, you made a statement to the police. Is there something different from that statement that we need to, or something additional you need to include, so that our affidavit is done in a way that a defense counsel can't go and attack that person's credibility in the family perspective. But now let's go on to the other side, where I'm representing someone who maybe our firm is representing on both sides, and they don't have the particulars yet. So I don't have a clue what the disclosure is. And what are we going to say in an affidavit? Well, what we're going to say in an affidavit in that regard is a lot less about the actual incident. And we're going to let the party who wants to say XYZ things happened on XYZ date, we're going to say, look, we deny that this happened on how this individual explains it. Something different happened. However, because of the criminal proceedings, I am not going to make an affidavit with respect to that what happened, because I have advice not to. And a judge is going to understand that, because the other counsel is going to go and say, well, they're saying absolutely nothing happened, and they're not even explaining anything further in here, and actually, in fact, minimizing it and saying that nothing, they're not saying anything, but putting in a sentence that explains that I've been advised by my criminal counsel not to discuss the incidents of that day, helps a judge say, okay, of course. So, but now how are we going to deal with the children issue? But then you can get so much other material in, for example, the history of the relationship with the children, the history of who did what and how it was done, and how the children are close to or not close to. Usually it's close to, because otherwise they're not coming and drafting an affidavit and spending the fees on that with the parent. And for example, sometimes they're coaches, they're the children's coach and whatever sport they're playing. So we have to make sure that they can continue doing that, because it's not only going to impact the child, it's impacting an entire team. So there's additional things that we have to consider and look at. So it depends on what spectrum we're at and how we're going to deal with that, right? And the nice thing is I can walk down the hall and say, hey, look, I need to put some things into an affidavit. Are there things here you think that just shouldn't go in there that's going to impact? And then I'm going to put that in that regard, with that, you know, the client has this advice and they can't do that. And courts understand this, but the parties, the opposing party may get really frustrated seeing that, saying, you know, this person is not even taking any responsibility, and they're pretending like nothing happened on that date. That's for that person's lawyer to explain, well, no, that's not what they're saying.
And in terms of gathering that material, one of the other interesting intersects between family and criminal law is the evidence that we're trying to gather. So I can't stress enough to my clients, because typically it's a he said, she said type of situation. There's not witnesses for these allegations of domestic abuse. You have one person's credibility pitted against another. And I can't stress enough to my clients, if they can provide me with any material that can corroborate their version of events, that can be hugely beneficial in terms of representing my client's interests, whether that's trying to persuade the Crown that we should be resolving this file, that if you take it to trial, you're not going to win, or using that material at trial to impeach the complainant, attack her credibility or his credibility, or attack his or her reliability as well. And we are living now in the age of social media. So it's amazing what type of material you can discover. You know, one of the first things I do after I interview a client is simply to punch in the name of the complainant. And there's all types of stuff out there. You know, there's people, you know, they post all kinds of amazing things on Facebook, which can be contradictory in terms of what they're telling the Crown. So I tell my clients to maintain any type of documents, if they have any videos, if they have a witness. For example, you know, video evidence can be very powerful in a criminal courtroom. When you have a complainant testifying to something and there's video or audio recording, which is contrary to that, that can be devastating to the Crown's case. But at the same time, there are problems on the family law side of things. And I know that, and I'll ask Uphar in terms of my next question, you know, video recordings are often frowned upon on the family law side of things. So that evidence, which would be great for a criminal lawyer, is not necessarily great on the family law. So can you expand on that a bit?
Yeah, it depends on how evidence is brought in. So if it's a surreptitious recording, so for example, I'm going to record you and we're having an argument, but you don't know you're being recorded, I know that I'm recording, and of course he's escalating, and I know how to push the buttons. If I take that to court to show, look, he's big bad bear and he's a terrible individual, a judge is going to turn around. Most judges are going to turn around and say, well, weren't you the one making the recording, and you didn't let this individual know that you were making the recording, and you're saying these additional things. So that's where it's going to be really frowned upon, and that's not going to look good. Or other things such as hacking into each other's email accounts and getting information and using that against the other party to prove your point, which may exactly prove your point, but the way you get the information, a court may not let you get that in. So you have to establish how you got the information and how you had a right to. So for example, we share passwords with each other, and I went in and explained that I went in and I got this, and he knows that I have this because from time to time I go and I pay his bills through here and I do XYZ. So I had access to this information. That helps significantly, because now the judge is not as irritated with my client for doing such a thing. But generally, if you're having a phone conversation or some kind of the party recording the conversation has to be an active participant. If it's somebody else, for example, you get your mom to make a video while the two of you are having some kind of conversation, and that person swears an affidavit and says, I recorded this on XYZ date, that's not going to be allowed in, and that's going to be frowned on. It's going to look atrocious, right? But if there's surveillance, like your home has a video camera, security camera, that's going to be allowed in, because it says, look, she says she's so afraid, and here are the bail conditions. She went and made this report, but here's 10 times that she's knocking on my door, coming to my house. I'm not answering the door because I'm afraid to open the door, but here she is doing these things. This does not look like an individual who's afraid, and you can, that's going to help. So it depends on how it's going to be used. I'm noting the time. I want to quickly touch on some immigration aspect. I just want to quickly know how many people in our group here work with individuals that have immigration consequences.
If you want to use the hand raise, I can count. Anyone? Okay, let's see. 1, 2, 3, 4. Can Uphar, can you see the screen, or do you want me to?
Yeah, I see hands. So now I see hands, so that's good. I want to definitely explain some of the immigration aspects. So there are many times where I have clients that are on a student visa, or they don't have their permanent residency here in Canada, and they're afraid to leave a relationship because they're either married to a Canadian citizen, or they're in a relationship or common law with a Canadian citizen or permanent resident. And that's their hook to keep them in this relationship and continue to abuse them. I always remind people that there are multiple ways that the Canadian government will understand. I've had people that are actually married, and the spouse never sponsored them, even though they're, continue to be in the country. So we can do. You can apply to the government and explain your scenario, especially if there's criminal. It's helpful to show that this person has been charged with domestic violence, XYZ. It's helpful to say we have a family law proceeding, but what's called a humanitarian and compassionate grounds application. And this is so important to explain, because these individuals have ties beyond their partner in the country, and they've been victims to abuse. We have an avenue for them to be able to stay and obtain permanent residence. If your client is a permanent resident already, and they're afraid that they have to stay for 2 years in this relationship, because that was a law previously. But even with that law, when that law was in place, nobody has to stay in an unsafe environment. Nobody has to put up with domestic violence, but we have to inform the government and let them know. So in 2022, the law changed and got rid of that archaic law that came in. It came in just for a very little period of time, but it was quite problematic, where when an individual sponsored their partner, they had to continue to stay in the relationship for a period of 2 years. The intention was to avoid sham marriages. However, what it did was, and maybe it helped with some sham marriages, but the larger problem ended up being domestic violence. So, because people were staying in atrocious relationships because of the fear of losing their opportunity to be able to stay in the country. I want everyone to know that if there's domestic violence, and domestic violence, again, I said this before, and I want to say it again for those that came in late, is not just physical abuse. It's emotional, it's financial, it's coercive control. So it depends on how the person doing your interview is going to ask you all of these questions to put a good package together. That's imperative, and they can apply for a humanitarian compassionate grounds application. So it's important to tell these people, hey, you might not have status, or don't be worried about your status. Go talk to a lawyer that does immigration work and can explain what your family situation is, or your life situation. You might just be in a dating relationship with a person, and some people, they can't even go back to their home country because of additional fears that what will happen to them there. For example, if they had a child out of wedlock, that's still a live problem in many countries, and many families are going to disown, harm. So those are things that we can apply to and let the government know and make an application in that regard. On the flip side, sometimes there's files where, many times I should say, there's files where accused are charged and sentenced with something that's going to make them leave the country. They're going to go under what's called a deportation hearing. I'm not going to go into the details of the laws in the areas. What I'm going to explain and overall is that when something like that happens, there's still a way, multiple ways, to try to keep the people in the country, because they may be the sole bread providers for their family. They're the sole income earners. Their ties in the country are significant. Even if the parties have separated, doesn't mean that that individual cannot make an application to stay in the country, because they may have Canadian citizen children. They may have other ties here. So immigration, there is a strong intersect in both of these areas. And I think it's really important for people to not just talk to a family lawyer or a criminal lawyer, to also make sure that they get the immigration aspect, because these other lawyers, if you don't practice in that area, you don't necessarily know what options are available to people. And that's imperative to get that advice, because people will make poor decisions based on not having any knowledge, right? Or they're just focusing on the criminal file, or focusing only on the family file, when all of this other area of law is live and it's going to impact your children. Some people probably don't want their partner out of the country if they have children, right? Others might prefer that, and that's a separate issue.
Yes, and these cases are often what I'll call triple headers. So there's starts with a criminal file, with an assault or something more serious, and then you have the family issue, and then this individual either does not have status in the country or is a permanent resident, and even permanent residents can be deported if they're convicted of more serious offenses such as assault causing bodily harm or assault with a weapon. So we have to, as counsel, be very cognizant of what the immigration issues are. So sometimes you have an individual who, in terms of criminal consequences, may be facing some jail time, but the immigration consequences are can impact the person's entire life. They can be out of the country, deported, and there's no recovery from that. I see a hand as well.
Yeah.
Yeah, I just, pardon my voice, actually, I have a sore throat. My question is about temporary work permit. I heard with the onset of pandemic, it was put in place, especially for the victims of violence. But I heard that it has been taken away by Canada Immigration. Is that correct?
If people had a temporary work permit previously, they still can apply, and each scenario is different. So we have to look at the individual's factors, if they can reapply, if there's a different way for them to be able to say. So there's no one set of advice that can go, that's a boilerplate answer for everybody. So really, if they're domestic violence and they had a temporary order, they may be able to stay here on a permanent basis with a PR explaining the situation, what they've encountered, and do a humanitarian compassionate grounds application. That was always there. The temporary work permits were put in place because people couldn't leave the country, because not to make open up a new avenue for immigration. I just want to make that really clear. So just because they had this for a certain period of time doesn't mean that there isn't another option or another avenue. They should really meet with an immigration lawyer and talk about get advice about their specific scenario.
Yeah, so I think we'll finish off on the topic of just, how do these files end or conclude? So in terms of a criminal lawyer, right from the outset, we're very cognizant of what the ultimate goal is. And the typical types of resolution on the criminal side of things are, if you're going to trial, the best possible resolution is an acquittal. That means you are innocent in the eyes of the law. Oftentimes you're not getting to trial. You don't want to take that chance. You don't want to, go to trials like going to Las Vegas. You're gambling with your client's future. If you get the wrong judge or the wrong set of facts or a combination of those two, your client might be found guilty when you felt that they were innocent. The other resolution that we often see, which is more typical, is to have Crown stay the proceedings. So if we can convince the Crown either that they do not have a substantial likelihood of conviction, or that's no longer in the best interest of the community that the file proceed, the Crown can stay the proceedings. Now, that doesn't mean that the client was not guilty or didn't do what they are alleged to have done, but it does mean the Crown has changed their view on the charge approval, and they don't feel that the charge should continue for whatever reason that they're relying upon to do that. The other very typical resolution for a criminal file is what's called a peace bond. So with a peace bond, you're not admitting guilt to the initial allegation, but you're admitting that there's a reasonable fear that exists in the mind of the complainant at the time with regard to your client. The peace bond, you can have a peace bond where after the peace bond, the client is actually allowed back in the residence. So it doesn't mean that there's no contact or the relationship is over. Peace bonds are very flexible. You can have peace bonds with no contact orders or without. And you often see peace bonds in relationships that are going to continue. There's guilty pleas as well. That means your client has accepted guilt for the offenses, and then you're arguing as a criminal lawyer, advocating for the best possible sentence. And that's where you're advocating for either a sentence that does not result in criminal records, such as a conditional discharge, or you might have something like a suspended sentence or even jail time, which results in a record. And the goal is always to avoid that criminal record. So last question for Uphar. What impact do you see in family law with regard to a peace bond versus a guilty plea, or even on the immigration side of things in terms of these resolutions?
Well, for the immigration, because that one's easier, I'm not concerned if there's a peace bond and deportation. That typically doesn't occur. So that isn't an issue. But when there's a peace bond and one party has said that there's these allegations, we're always reminded that we remind our clients that, look, they're not saying that something didn't happen. They're just saying that what you say happened is not exactly what happened. So there's two sides to every story. And family law is not an opportunity to relitigate the criminal aspect, but the evidence is allowed in. So some counsel will say, hey, no, my client accepted a peace bond or did a guilty plea, and none of that should come in because a separate court has already dealt with that. Well, our Family Law Act recognizes domestic violence. So those, if they are important in the decisions a judge has to make, a court will recognize what happened, will hear both parties' story of the event that allegedly occurred, and the lawyers will have an opportunity to cross-examine them, and then the judge will decide what is more likely to be true, not likely to be true. Was there domestic violence, or was this was it perceived, or was there just an isolated incident, or is there a long history? And a judge will listen to all of the family law judge will listen to all of that evidence in making their decision, because it may impact who has the parenting responsibilities, right? Who has the primary residence? For example, if there's a history of abuse, the parenting responsibilities may not be best suited that they be joint. It may not be best, the maximum contact principle, maximum parenting time principle may not be appropriate for that family. So the entire story has to be told.
Yeah, so just lastly, so we may recommend to a client, take this piece bond in terms of the overall scheme of things, but just know it can still come back to haunt you on the family law side of things. So even though there's no criminal record, you're not going to jail, and the family law side of things, this can still be weaponized against you.
And I have to remind people that there's lots of opportunities for out-of-court dispute resolution, and I think that's something that I'm a family law mediator as well. We don't always discuss, and just because there is domestic violence and there's abuse allegations doesn't mean these families cannot resolve their issues outside of court in that type of environment, because trauma, there's so much trauma associated with litigation to all parties. But if you're a victim, if the person you're helping is a victim, I think having that conversation about, this is going to also cause more trauma. Do you really want your story heard by a judge that is going to judge you and make it and doesn't know the entire story, because within a few days or an hour or two, are they going to know you and believe everything and understand everything? Or is it better for you to try to get into a mediated type environment where it may not be what you believe is the right thing or the perfect thing or the best scenario, but it's got enough protections in place where you've made some agreements, and then you have an agreement. And quite frankly, sometimes you can make amazing orders in there that later on, if an individual does some further abusive types of things, you can refer to the mediated agreement that says, this person was not supposed to drink alcohol 24 hours before or during parenting time. We made this agreement in mediation. I trusted, and they would do that. But look, the first time he gets parenting time, I can smell alcohol on him. He can't come and say we made this agreement in mediation. So that's just something else I want people to think about is out of court settlement. And the family justice counselor also has free mediation for families too, because I know a lot of you work with people that don't have the funds to be able to pay for a mediator. That's another way to do it. And there are family law lawyers who are also mediators and counselors that are also mediators that will work with individuals without counsel. They'll just send them out for what's called an ILA, independent legal advice, to sign off on it. And if they're given that option, doesn't mean people have to go and obtain the legal advice. It's always important to be able to do.
I want to say thank you so much to both presenters. We are 5 minutes over time, but we did start a little bit late. So if you're okay, I can open it to questions one more time, if you don't mind. Recognizing that a few people have, with their gratitude to both presenters, had to sign off, but they let us know in the chat that they are very thankful for this. Okay, so we're hearing excellent presentation. Thank you in the chat. So yeah, it doesn't look like anyone has anything super urgent right now. It's just a lot of people saying thank you. So I'll turn it back over to you two to wrap up.
Thank you.
Thanks all.
Thank you.
Okay.
Thank you, do.
Thanks so much, everyone, for being here. Thank you to both presenters. Really appreciate it. It was an excellent presentation. I love this style of presenting. I mean, PowerPoints are great too. I don't want to say, people who do PowerPoints are boring, but this was a great presentation. It was a lot of fun. So thanks so much. And yeah, the chat's blowing up with lots and lots of thank yous. So thank you to the presenters. Hope everyone has a great day. Bye, everybody.
Holidays.